Hello everyone, hope you're having a great day today. So today we're talking a little bit about working conditions, and this is actually something that we had discussed in the interview last week with Mark Bowling, and it's in your discussion for today. And so really with this, the laws and regulations that arise are in the employment and workplace issues affect everyone. Even if you're not a decision maker, it still affects everyone from the entry-level employee to the highest executive. Employment law and workplace issues are those that are recurring. And so this chapter introduces some basic concepts related to the Fair Labor Standard Act and Occupational Safety and Health Act, or OSHA. Working through these laws and regulations can be rather mechanical, but the workers' compensation section will provide you with an opportunity to conduct some case analysis to strengthen your problem solving and critical thinking skills. So use this chapter as a refresher regarding the source of law. Both the Fair Labor Standards Act and OSHA are federal laws that are administered by federal agencies. So a number of federal regulations or administrative laws are involved. So with that, federal laws apply to all employers in every state. So a decision interpreting one of those laws in one state may have some precedential impact in another state. And the workers' compensation laws are state statutes and may vary from state to state. So a good exercise would be to locate some of the workers' compensation laws for your state and examine how those provisions have been applied to some of the primary issues in the sport industry. For example, whether a professional athlete or collegiate athlete is a covered employee, or whether an injury occurring during corporate recreational outing is a covered event for purposes of workers' compensation. So, getting started, these are the management context and relevant laws and cases with employment discrimination that arise. And so with that, looking at determining employee compensation and job duties, of course, that falls under the FLSA, and really look at overtime, your minimum wages, and exemptions for administrative employees and amusement businesses. Kind of some interesting concepts there, and I think things that we're working through now with minimum wage increasing in different states. The use of interns and trainees, and that's something that's really near and dear to my heart as the internship coordinator. That falls under the FLSA. And then creating a safe workplace, which looks at on-the-job injuries and is really under the governance of OSHA. And then employer liability for injuries to employees. So that's more under workers' compensation under state regulations and programs. So the Fair Labor Standards Act is one that it provides, or it's the law with the greatest impact on working conditions in terms of wages and hours. It was passed by Congress in 1938, but it's administered by the U.S. Department of Labor's Wage and Hour Division. It impacts your working conditions, wages, and hours. Its objective is to eliminate labor conditions that are detrimental to minimum standards of living necessary for health, efficiency, and general well-being of workers. There are standards for minimum wages, overpay for record keeping, and child labor. So it protects more than 130 million workers. Now, what FLSA does not regulate or require is it really provides enterprise coverage. It applies to employees who work for businesses or organizations with at least 2 employees and do at least $500,000 a year in business. It also provides individual coverage in cases where an organization does not qualify as an enterprise, but an employee engages in activities involving commerce. What it does not regulate or require is vacation, holiday, severance, and sick pay. It does not cover meal or rest periods, holidays, or vacations. Pay for weekend or holiday work, your pay raises or fringe benefits, or discharge notices or reason for discharge. So it really doesn't look at any of those things. It really is looking at minimum wage and overtime wages. So it's really up to the organization to determine, the vacation, the holiday, and how they're going to set up their schedules, their work schedules, more or less. So with that, there are some minimum wage and overtime requirements. FLSA is intended to provide broad protection to employees. so that all employees are covered unless an employer can qualify for one of a limited number of exemptions. What they look at is that the maximum working hours is about 40 hours per week. Federal minimum wage is currently $7.25 per hour, but that varies from state to state. For example, Texas minimum wage, you probably know this, is $7.25 an hour versus California, which is their minimum wage is $10 per hour. Now, the thing with that, and I was talking with someone this weekend about it, with the increase in minimum wage, that really sets the stage for increases across the board. And you see an increase in the standards of living in those areas as well. And if any of you know, California is already extremely expensive to live in. And so across the board, it increases the standard of living. It also increases, it's a big increase for the organization, how to compensate for that. So hourly employees working more than 40 hours per week are entitled to overtime pay of at least 1.5 times the normal wage. And you cannot waive the right to overtime pay or agree to work more than 40 hours at regular pay. A lot of times what will happen is that rather than having more of your managerial type people, rather than paying them for overtime, they'll put them into a managerial position, which is a salaried position. And we'll talk more about that in just a moment. So what are some of the pros and cons of establishing a minimum wage? Do you think the minimum wage should be increased? Why or why not? So looking at the exemptions under FLSA and the sport industry in particular, an exempt employee is one who is paid on a salary basis. That's a predetermined amount of money for work performed, regardless of the hours actually worked, and they are not required to track their time worked. Exemptions are premised on the belief that the exempted worker typically earns salaries above the minimum wage, and these workers are presumed to enjoy other compensatory privileges such as above average fringe benefits, greater job security, better opportunities for advancement compared to the workers entitled to overtime. Now your executive, that includes your executive or administrative workers or your white collar workers. We're also going to talk a little bit about amusement or recreation employees. They're considered to be exempt, and trainees and interns. Now, a non-exempt employee is one that is paid based on the actual hours worked, and they are required to track all time worked and to be paid overtime for time worked in excess of 40 hours in a work week. For example, at Emory University, exempt employees are paid bi-weekly. So some of the staff at a university or even in an athletic department would be paid on a different schedule than the exempt employees. So there are some white collar exemptions. There are 3 tests with that. The salary basis test. With that, employee must be paid a set and fixed salary that is not subject to variation, regardless of the number of hours actually worked or the quality of the work. Another exemption would be the salary test, and this is the amount of the salary must meet a minimum level. And so here, at this point, it was $55 per week or $23,660. This actually increases this December to $47,476 per year. So it's in essence doubling what was set in these regulations. And in our discussion, one of the things that Mark and I talk about is, they're expected to go and make these changes by December of 2016. And one of the things that might have been nice would have been to have like a few jumps up to that rather than it automatically doubling. The duties test, and this is looking at the employee's duties. Most of those should be primarily involved in the executive or administrative or professional functions of the business. And so they're making decisions is really what that amounts to. A business found liable for not following these exemptions could pay thousands of dollars in penalties, back wages, and legal costs if it incorrectly categorizes an employee as an exempt employee and fails to pay overtime or minimum wage. So some of the exempt employee categories would be an executive. And in this case, if you look at sport organizations, this would be like the athletic director. They oversee all of the duties, and therefore they would be in that exempt category. You're probably going to see them at a higher salary level than the $47,000 that we were talking about. Administrative, primarily their duties are to really, it's about decision making. They exercise discretion and independent judgment with respect to matters of significance, and implies that the employee has authority to make independent choice, free from immediate direction or supervision. Comparison and evaluation of possible courses of conduct and acting or making decisions. So something along the lines of like a sales manager. So they have some managerial expectations. There's not a whole lot of supervision. They're basically, this is your job and you're allowed to perform it how you prefer. The learned professional is one that would be like your college faculty, your professors. A creative professional, this would be someone who is a photographer or has a little bit of freelance opportunities. Computer employee, this would be your IT person. And then you've got outside sales representatives would be considered exempt. Now, amusement or recreational exemptions, you know, the sports and recreational industry is one that we employ an awful lot of people. Some of these sports and recreational facilities only operate a few months out of the year, such as a sport camp or amusement park or swimming pool. So they may not be open the full year. So workers at a facility that operate for only a few months are considered to be exempt under these two tests. Number one, that the facility does not operate for more than 7 months in any calendar year. And number two, if a facility operates for more than 7 months, but the majority of their earning occurs during the end season. So average receipts for any 6 months were not more than 33.3% of average receipts for the other 6 months. So you see this with some facilities. Now, I would say many facilities now, I mean, I'm thinking, you know, like the Whataburger Field, American Bank Center, they operate pretty much year round now. And so they could not claim these exemptions. There are some that only operate during the summer. And so they would be able to claim those exemptions. So, for example, an amusement or recreational establishment operated for 9 months in the preceding calendar year. The establishment was closed during December, January, and February. Total receipts for May, June, July, August, September, and October, so 6 months, in which the receipts are the largest, totaled $260,000. A monthly average of $43,333. The total receipts for the other 6 months totaled $75,000. So a monthly average of about $12,500. Because the average receipts of the latter 6 months were not more than 33 1/3% of the average receipts for the other 6 months, this Section 13A3 exemption would apply. And as the internship coordinator, interns are near and dear to my heart. I believe in encouraging students to volunteer to seek internships, whether they're official or unofficial, to improve their employment opportunities. It gives you great means for building skills. But there's a lot of criticism in the sport industry regarding the compensation of interns. And you guys have seen videos of the internships from hell. And a lot of interns are taken advantage of, and that's one of the reasons they have created these exemptions. So with that, compensation is something that is very important to look at with an internship. Another thing is whether the interns are employees under the FLSA depends on circumstances surrounding their activities on the employer's premises. So some interns are paid, especially in the sport industry, they may be paid for the game, but not necessarily for the activities leading up to the game. So the marketing duties that they perform before the game, but then they're paid to participate at the game. So some things along that line. The burden is really on the employer to demonstrate that exemption applies and criteria are satisfied. Here, sorry, let me go back. There are certain criteria to claim as an internship exemption from FLSA, and one of those is that the internship is similar to that which would be given in an educational environment or structured as a classroom or academic experience. And I will tell you, really, those are the kinds of internships you want to find. Those where you're going to be given training. That's what an internship is about, is training. Another criteria is that the internship is for the benefit of the intern. So it's providing them with skills that can be used in other settings. Third, the intern does not displace any regular employees. They should be working under close supervision of existing staff. And so they're not firing employees to hire an intern or to have an intern. The employer that provides the training derives no immediate advantage from the activities of the intern. So it's not for the benefit of the employer, it's really for the benefit of the intern. Now, it says that, but in my experience, usually what happens is that there is a benefit of having an intern there. It usually takes a little while. You've got to train them and put them through some training before they can get to that point where they are of benefit. But now with that, an intern is not someone who is entitled to a job at the conclusion of the internship. So there's no promise of that. And the employer and intern understand that the intern is not entitled to wages for the time spent in internship. A written agreement stating payment for the services is neither intended nor expected. And this is probably a big change. The really hiring interns, what I'm seeing is that they're not calling it interns anymore. They're actually giving it a different title, and they're being paid more or less minimum wage. So that's something that I'm seeing in the industry now. There are some unofficial type internships where there's not any academic expectations on it, but that's really why your internship is so important. It's about giving you skills that you've been working toward with your school and being able to apply those in a situation, and really helps you in getting that next job or getting that first job. Now, volunteers, they are an important element in the sport and recreational industry as well as event management. And so it can also be a means for gaining meaningful experience. And so many employees may not volunteer to do work that they should be paid. What you'll see oftentimes is that the employer asks someone to volunteer, and even though it's associated with the organization, it's on a date off when they wouldn't normally be paid. They're being asked to volunteer. So volunteer, this is the definition. Really, your volunteer service should be offered freely and without pressure or coercion, direct or implied from the employer. The definition of a volunteer is someone who is an individual who performs hours of service for a public agency, not necessarily for profit, but public agency for civic, charitable, or humanitarian reasons without promise, expectations, or receipt of compensation for services rendered. Now, there are certain situations when employees can volunteer to for-profit or private sector employers. Those activities occur outside the employee's normal working hours. There's no obligation to participate or ramifications for choosing not to participate. The employees have no expectation of compensation for their time helping with the event, and the activities performed are different from their normal duties performed by the employees. Some penalties for violating the FLSA. The Department of Labor investigates many of those alleged violations. In 2008, there were almost 30,000 compliance actions, which resulted in about $9.9 million in civil penalties and $186 million in payment of back wages. Now, employers that willfully or repeatedly violate the minimum wage or overtime pay requirements will pay the first offense. They'll pay a civil monetary penalty of up to $1,100. For a second offense, it's possible imprisonment. So, some competitive advantage strategies to comply with FLSA are: number one, we regularly review and prepare employee descriptions and duties for new and existing positions. Determine which positions are non-exempt and which are exempt. Evaluate the status of your seasonal employees. So your seasonal employees, they're there for Christmas, or maybe it's your competition season, your end season, your game seasons. Maintain good work records for at least 3 years. Evaluate your part-time employees, as well as your independent contracts and interns, to ensure that FLSA requirements are met when applicable. And make sure that you use a written internship agreement to address training criteria. Now, the Occupational Safety and Health Act of 1970 is administered by the Occupational Safety and Health Administration, or OSHA, through workplace inspections and investigations. It covers private and some public sector employers and employees. Employers have a duty to provide their employees with a safe and healthful work environment free from serious hazards. So the functions of OSHA are to, number one, set standards and to conduct inspections to ensure workplaces are safe and healthy. Now, there is a general duty clause, and basically this says that each employer shall furnish a place of employment which is free from recognized hazards that are causing or are likely to cause death or serious physical harm to their employees. The specific hazard standard requires employers to adopt specific practices, means, methods, or processes reasonably necessary and are appropriate to protect workers on the job. Most of OSHA looks at manufacturing, construction, and transportation industries. There is the OSHA Division of Education and Training, and really what they find is that training your employees and using personal protective equipment that's required for safety and healthy is important. Employees may comply with rules and regulations that apply to their own actions and conduct. Now, there are some examples of OSHA in sport organizations. With that, there are safety standards that are related to building a new stadium. Of course, wearing the hard hat. There are certain clothing recommendations, boots. But some other thoughts as well are the ergonomic design of your computer stations, to alleviate back problems, having standing workstations. There's also guidelines for preventing disease transmission of bloodborne pathogens. And that's something that we see in our industry, in the sport and recreational industry. Injuries occur. And so knowing how to prevent disease transmission of bloodborne pathogens is really important. Competitive advantage strategies for workplace safety and health. Make sure that you display all OSHA information in posters where people can see them. That means your employees, and also good to have some displayed for your consumers, people coming to your facility. Determine which OSHA standards apply to your organization. Identify and correct violations that might be there. So having someone come in and do an audit of sorts would be important, so that, because oftentimes you may not see the same things that someone else has. Making sure that cords are stashed and not laid out on the floor, things of that nature. Establish a team to deal with catastrophic events. I would say it's good to have a good team, a good core team. Now, it's also important that you train other people, all your people, to deal with events and things that might happen, and on a regular basis. Determine who is responsible for overseeing safety and health concerns. So having an OSHA contact. Maybe it's a manager that oversees everybody. Review your safety records to ensure that the organization is in compliance, and keep all training and safety manuals up to date. That means making sure that you are up to date on regulations that come out periodically as well. So the workers' compensation laws, these are passed by each state to remedy injustice when someone is injured on the job. So it provides compensation for workers who are injured on the job, and really designed to help eliminate the need for litigation. We tend to be a litigious society already, and especially here in Corpus Christi, it seems like it's really large. Basically what it does, these workers' compensation laws provide benefits for dependents of workers whose accidents or illnesses have resulted in death. And they protect the employers by limiting the amount an injured employee can recover and fellow workers. Now, employees are entitled to benefits regardless of who is at fault. The injury may be the result of a single incident or the result of work activities over time. These essential elements must be met, and an employee engaging in voluntary physical activity during business hours is covered if acting within the scope of employment. Now, one thing that you see in our industry, of course, as a fitness instructor, is that that's something that they're doing physical activity. This would be, of course, voluntary physical activity within their scope. Employee is limited to recovering the predetermined amount based on the worker's level of impairment, payments for medical expenses, and degree of disability. And that is determined by the state's workers' compensation scheme and formula. So some elements entitling an injured worker to workers' compensation: if it is a compensable injury, meaning a worker must suffer a physical injury or illness. Psychological or emotional injuries are often excluded from the coverage of this act. These laws exclude compensation for injuries that are intentional or self-inflicted, resulting from either horseplay or from intoxication or alcohol or drug use, voluntary participation in an off-duty recreational, social, or sporting event. Others would be results from the acts of God, where it could be like a flood or something along that line, unless a person's job exposes him to greater risk for injury from such acts or inflicted by someone else for personal reasons unrelated to employment. Accidental. This would be another element entitling them to workers' compensation. And this would be, it could be that the employee's own negligence contributed to his injuries. They would still be entitled to workers' compensation. Something that arose out of employment, the injuries tied to a condition, activity, or requirement of their employment. And there's 5 criteria for that. And number 1 would be whether the injury occurred during their working hours. Another one would be whether it occurred on the employer's premises, and that the injury occurred during an activity initiated by the employer. Another condition would be whether the employer exercised any degree of control or direction over the employee's activity. And then lastly, whether the employer benefited or stood to benefit from the employee's activity. So there could be an injury that's made during a delivery or walking through a parking lot. Voluntary physical activity that occurs within the scope of employment for purposes of workers' compensation might be, again, for like a fitness instructor. So what do you think of the example of the worker who sprains her ankle during a company softball game? Is she entitled to workers' compensation? Interesting thought. So looking at workers' compensation and athletes, these are typically accidental by nature of the injury. That's pretty critical. And, really the nature of the game could be violent as well. So many professional athletes, injuries are possible. It's part of the nature of the sport itself. So there has been some a recent increase in compensation claims filed, especially in California. You're also seeing this in line of those athletes that have been retired and coming back with the concussion issues that have been out in the public lately. Here, engaging in conduct that is physically dangerous and that has a likelihood of injury, players must automatically expect to be injured. Now, with college athletes, players must suffer an injury while playing for an institution. Courts have consistently determined that student athletes are not employees of the school. And there's some contention on that. On the other side, receipt of an athletic scholarship constitutes an employment contract for exchange of athletic performance and payment of scholarship monies. So there's a lot of contention in that area. And what they say is that workers' compensation benefits are not applicable with college athletes. Now, workers' compensation insurance. Employers must secure insurance to cover claims. That's one of the means of controlling the in preventive law. And so with that, the cost of premiums is affected by the number of injuries at the workplace. Premiums are also affected by employee risk category. And not all employees have the same physical demands. So depending upon their job, there may be some jobs that have more physical demand than others. And with that, of course, with the high demand, there are higher premiums for higher risk activities. So you've got to negotiate all of those criteria and really evaluate the situation. Now, as a competitive advantage strategy in workers' compensation, you don't mandate or reward employee participation in company-sponsored teams. It might be something that's done as a socialization activity, team building type activity, but you don't necessarily mandate it or reward for that. Make sure that employees know that participation in those events is something that is voluntary, and so they have the choice of whether to participate or not. You also want to make sure not to hold any sport or fitness activities on company premises. I'm kind of at odds with that one just because of the nature of the business. I think it would depend on that. Anyway, do not try to control these events. Contribute only economic support. So put the money out there and let them dictate the event itself is basically what it is saying. Make sure you research your workers' comp's premiums and try to get lower risk classifications when possible. Again, so looking at the types of demands for the job and what kind of risk is involved with it. All right, that concludes our activities for today. I look forward to seeing your discussions on about the working conditions and the FLSA. Talk with you soon.